Speaking at the National Conference on Decriminalizing Petty Offences in Ghana was the former Commissioner for Human Rights and Administrative Justice, Justice Emily Francis Short, stated that African Commission on Human and People's Rights has over the year expressed concern about the overcrowding of prisons in Africa and have recommended a decriminalizing of petty offences to be addressed in solving the problem of overcrowding of African prisons.
And have recommended the decriminalization of petty offences as one measure to address the problem of overcrowding in our prisons. Consequently, the Commission began to advocate for member states to address the disproportionate effect of petty offences when in 2003 it adopted the Ouagadougou Declaration and Plan of Action on Accelerating Prison and Penal Reform in Africa, which endorsed recommendations calling for reducing the size of prison populations in Africa. The plan of action recommended the, quote, decriminalization of some offenses such as being a rogue, a vagabond, loitering, prostitution, failure to pay debts, and disobedience to parents as a strategy to reduce the prison population. The Commission, in recognition of the need to provide further guidance to member states, adopted in 2017 the principles on the decriminalization of petty offences in Africa. You must first decide what you consider to be petty offences in our criminal code, which disproportionately affect the poor and vulnerable. You must then consider whether decriminalization of those offences will alleviate the serious issue of congestion in our prison.
According to the Commissioner for Human Rights and Administrative Justice, Mr. Joseph Whittard said petty offences can still be punishable but not to be subjected to criminal sanction.
If these are socio-economic issues, why do we apply criminal justice punishment? Can't we find a way by which we can still hold the balance by declassifying these offenses, making them still punishable for one reason or the other, but not subject to criminal sanction? That is possible. The Commission on Human Rights has equally organized joint in-country workshops with the Africa Commission on Human and People's Rights for justice sector institutions to provide knowledge and tools for advocacy to staff of the Office of the Attorney General, Prison Service, Judicial Service, and the Police Service, and a number of CSOs on the principles of decriminalization and declassification of petty offences adopted by the African Commission on Human and People's Rights.
Deputy Attorney General and Minister for Justice, Honorable Godfred Dame said the Ghana government has proposed for criminalized petty offences to be removed from Ghana criminal law and be diverted into alternative mechanism operated by municipal assemblies in order not to diminish the dignity of the disadvantaged persons.
These are matters that we need to look at when it comes to petty offences in Ghana. In Ghana, examples of such offences may be found in section 296 of Act 29, which criminalizes actions such as throwing rubbish in the streets in subsection 1, committing a nuisance while in town in subsection 2, making loud noise to the annoyance and disturbance of any person in subsection 7, idling in a public place in subsection 21 among others. The proposal to decriminalize such offences advocates that such acts and their associated penalties should be removed from the criminal law and diverted into alternative enforcement mechanisms operated by municipal assemblies in order not to diminish the dignity of disadvantaged persons or single them out for punishment on the basis of their status. These suggestions are made because urban and rural contexts supply various challenges to those living with limited means. With this background, the present proposal to decriminalize petty offences faces reasonable expectation of objections that removal of petty crimes the floodgate to the advent of disorderliness without consequences. Critical considerations of the claims made in favor of or against today's proposals are therefore indispensable towards charting a way forward for discourse and implementation. Having been free from colonialism for 65 years, the usefulness and efficacy of the laws we have chosen to maintain must be assessed by the application of empirical studies, where possible, towards an evidence-based approach to lawmaking. This approach will enable us to determine whether our resources are best focused towards other modes of maintaining safety and order. This would also serve as a means to assess whether we are achieving the true aims of crime control, which is to provide an environment for the peaceful pursuit of personal aspirations, performed in harmony with the well-being of other members of society. Mr. Chairman, it is lastly of concern that there remains significant numbers of convicted persons and remand prisoners in our prisons. The prison facilities are overextended, with a larger population seven times for various serious crimes. Prison service statistics indicate that majority of the persons are serving time or are on remand for felonies. It's highly undesirable to swell these numbers with persons who are arrested for these identified petty crimes when other means of redress may be utilized.
According to Mr. Joseph Whittard, in his interview with Nation One TV, said that there's a danger if such petty offences is going to be criminalized as a result of using it against individuals.
Holding or is fulfilling and protecting the rights of the citizens. So you may do well in country, but if you don't report to the international system, which you have an obligation because you are a member, then you don't know much about that. That's why I'll say most of this, the session that I attend at the Africa Commission in particular, Africa Commission on Human and People's Rights, the impression that one has is that they know Ghana is doing well in country, but there's nothing to show. There's no report to show that we are doing this. And so that is why I'm signaling the Attorney General, who represents the states in reporting, to do so. Not only at the African Commission level, but also at the UN level. Quite a number of treaty bodies have reporting obligations. Ghana has reporting obligations. We haven't done that. We need to do that. Throughout the day, we've been talking about, quote, petty offences. We say, yes, they are not defined, but they are minor offences. And we describe most of them, some of them. One, loitering around the street. You are loitering in what sense? Are you getting it? But if you put it in the context of the colonial government, where the colonial settlements were not supposed to be accessed by Africans or Gold Coasters the way they wanted at any time, then it becomes meaningful, right? So you cannot be seen loitering around, quote unquote, at the English establishment, government settlement, like we call it Adabraka official town, right? You know why we call it official town? It's because that was the settlement of the Gold Coast administration. At that time, you would be caught and punished. Now, does it make sense that 60-something years into our independence, ruling ourselves, we keep a law like that as loitering, being a vagrant, and similar laws that were meant to keep Ghanaians at that time, Gold Coasters, away from the English. So it doesn't make sense. The danger is that once they continue to remain criminalized, police can take them at any time and then use it against ourselves. And that's what is happening. So why don't we decriminalize, and then we have the opportunity to respect Ghanaians who can move around wherever they want, subject to respect for the law. Nobody is condoning any misconduct, but you should not be arrested in a so-called town because you are loitering. Are you getting it? So that's the context, and there are quite a number of those ones that I thought they were put there by the colonial government, received by our independent government at the time in 1960 as criminal offences, and continued up to today as well. That is